Good morning to all of you. Today we are going to discuss a case relating to the privacy of the data secured by the investigating officer during the course of investigation. So, the Karnataka High Court single judge bench, Justice Suraj Govindras, he held that the investigating officers will be held responsible and departmental action or penal action can be taken against them if they divulge the information retrieved through the electronic media to the third party. That means, no doubt, for the purpose of investigation, yes, definitely they can secure the call data records, the emails, the smartphone gadget data, all these things they can take. But the caution should be they should not divulge it to the third party. Definitely the third party will be so much interested. Even the complainant will also be interested, but they should not give the same. When they can give, all these things we'll discuss in this case. So actually this is the topic of the case is different. Actually Mr. Virender Khanna, who is an alleged accused in the very ill-famous sandalwood drug case. Actually, he has filed this petition. What happened is he was arrested. So the National Investigation Agency, they are conducting the investigation. The investigating officers, they wanted to conduct polygraph test to him, and incidentally they wanted to retrieve the data from his smartphone, from his laptop, from his hard disk, and from his email accounts. But he has put passwords to all of them. So they are all encrypted data. It's not possible unless you know the password. So the investigating agency, they filed a memo in the trial court. The trial court ordered the passwords to be given to the investigating officers so that they can crack the phone and they can take the details and they can take necessary action which is useful for their further investigation. At the same time, the court also directed him to undergo this polygraph test or lie detector test. So these two observations came from the trial court. So against to them, under Article 21 of the Constitution of India, saying that they invade his right to life, and also Article 20 Clause 3, that self-incrimination, he has approached the Honorable High Court of Karnataka. Actually, this is the problem. But Honorable High Court, definitely it has set aside the orders of the trial court, stating that the consent of the party, consent of the accused is 100% necessary to undergo the so-called polygraph test as per Article 20 Clause 3 of the Constitution. Now that is what is called self-incrimination. No doubt, there are certain instances where the person wants to undergo polygraph test to claim his innocence. In such cases, definitely is necessary. Of course, the court has got inherent powers. They can ask him to undergo the polygraph test. Anyway, in this connection, Karnataka High Court actually it has set aside the orders of the trial court. He need not undergo the so-called lie detector test. As regards the passwords and the things, yes, as per the investigation, if the investigation poses a question, definitely the accused is bound to disclose the passwords. Definitely the police officers can use their of course, if he doesn't, they have given a series of guidelines also. Karnataka High Court series of guidelines. If he is not giving the true password, or if he gives the false passwords, they can be, the instruments or the smartphones can be cracked through an ethical hacker and action can be taken. Like that, there have been restrictions also. Here, taking of the passwords or cracking the phone does not come under section Article 20 Clause 3. This is what is mentioned in this case. So this order does not violate Article 20 Clause 3 of the Constitution of India, and at the same time, according to Section 161 Clause 2 CRPC, the witness is bound to answer truly all the questions posed to him by the investigating officer. Definitely, he has to give the passwords. So, and cautionarily, as a precaution, the High Court stated that this information should not be divulged to the third party. If it is divulged, definitely the concerned police officers will face the charges for dereliction of duty or departmental proceedings can be initiated against the IOs if they are found to have furnished the information to the third party. Now I am telling you a practical example since I worked as a police officer also. Previously, we used to collect the call data details, CDRs, call data records from the service providers like Airtel, Vodafone, all these things. So for that, the permission from the superintendent of police was necessary. But with the case of Sri V.V. Lakshmana alias J.D. Lakshmana, who was working as the CBI joint doctor at the particular point of time when Mr. Jagan Mohan and others have been arrested. So at that time, some of the people, they have actually managed the investigating officers and got the information, third party information. At that time, it has become a big issue, and from that time onwards, if the police officers wanted to have the call record details, now they have to get permission from the intelligence IG. Intelligence IG only can give permission, otherwise you cannot intrude the personal details of any accused or any suspect or any person. So this is the background. So please remember, no doubt, people, what happens is, suppose a rich man's daughter elopes or she goes away. Normally he doesn't want to give any information, any report to the police. And what he has to do, so they will manage the local police, and he wanted to get information regarding the call details of the suspected persons. So he will influence the police, and this number will be placed along with the number of suspects, and this information will be taken and it will be given to the so-called rich person. These things do happen practically. That's why here it is very clearly stated that in case the IO gives the information to the third party, he is held liable departmentally or even legally also. In this connection, so all of us should remember the very famous Selvi case where the information once given, so they can collect the information, even it is not violate of Justice Puttaswamy's right, that is, we call it as Aadhaar case. It is not violation, but if he gives the information to third party, definitely it comes as a violation, and the investigating officer will also be involved in this case, right? So please read the judgment. This is basically regarding the polygraph test, but important point is regarding the privacy of the data, privacy of the information of the person, because we do not know, everybody has got own his information. He will secure it by means of the passwords. They should be secured. Of course, if they are necessary for investigation, you can take it, but you should not divulge this information to the third party. That is what is mainly emphasized in this case law. Thank you very much.